I call the honourable member, David Clendon.
Kia ora, Mr. Speaker. Thank you. Mr. Speaker, I've listened with interest to the contributions from the Labor speakers in particular, and I think it's fair to say that in the Greens we've come to a similar position that we will support this bill as far as Select Committee, but our support is highly conditional. We have major concerns about this bill. Its purpose is the proposition that we need to offer a level of protection, a level of comfort to people who have been the victims of violent crime. Undoubtedly that's a wholly tenable proposition, one we can support. But the mechanism, the content, the detail of this bill, we see that many fishhooks in it that we do have serious concerns about whether they can be ironed out sufficiently, and we will be supporting to Select Committee. We look forward to the committee process, we'll engage with it clearly, and we will re-evaluate our position, our support or otherwise at the conclusion of that. As I said, sir, the proposition that it's desirable to offer comfort to victims of crime, criminal offending, is the forefront in this legislation. It reminds me, though, again, that we seem to see a number of bills which seek to incrementally add some level of service to victims of crime. This country desperately needs a clean sheet of paper, an overall review, a sort of a zero-sum game about victims' rights. How do we address victims' rights across the board? That's something that the successive governments seem reluctant to engage with. And again, it's been a Green position for a long time that we need to get a cross-party agreement that we are not serving victims well in this country in all sorts of ways. We need to sit down and work out how can we do that strategically in an integrated way and not rely on these sort of amendments and additions and the meddling around the margins of legislation. So I'd just like to, clearly the core, what will eventuate if this legislation is enacted, is that a non-contact order will be created. And as we learn from the explanatory note, a non-contact order would prohibit an offender from having any form of contact with a victim, may also prohibit the offender from entering any specified area or from living or working in any specified area. That is an extremely potent set of conditions to impose on a person to determine where they may or may not live, where they may or may not work, what areas they may or may not enter. The consequences for a released person could be quite profound and actually counterproductive to their continued rehabilitation and reintegration back into society. A person who might, for example, be denied the right to return to a small town, despite the fact that that may be the place they're most likely to have family or other support networks, the place where they might find secure tenure, accommodation, the place where they might find a job and actually work to put their offending behind them, to become part of a contributing person in society. They may be denied that opportunity, the best opportunity they have to put their offending behind them and to get on with life. It just raises to me an interesting conundrum too. What would happen in the event that an offender is released from prison, goes to live and is working in a particular place, and then a victim of that person's offending chooses to move into the area where they are established? It's kind of a reverse sensitivity thing, and I'm not sure that this bill has anything in it to accommodate that particular instance. And I think it's one of the little details we'd need to reflect on, to think about. So successful reintegration of a former offender demands that that person commits to changing their behaviour, that they honestly and truly put their offending behind them. But as Anne Opie pointed out in her excellent study, she titled that transition from outlaw to citizen, there has to also be a social space. The community must also give a person an opportunity to redeem themselves, to demonstrate that they are actually willing and able to reform and to become contributing members. And some of the provisions of this bill could actually be counterproductive in that sense and count against the possibility of that person having the opportunity to prove themselves that they may once again be trusted members of society. I'm concerned at the definition of offender in this bill. It seems that a person who offends once will forever carry that label. It's the Shylock dilemma. You call me dog, therefore beware my bite. It almost sets up a situation for a self-fulfilling prophecy that by by labelling somebody forever as an offender could have a counterproductive outcome on their behaviours forthwith. So I think what this bill overlooks, and I was interested to hear some of the government spokespeople talking about the need to prevent victims being further intimidated, being persecuted again, victimised again. In fact, the status quo protects people against those very things. If I seek to intimidate or persecute someone, the law will be onto me, and quite rightly so, very quickly. But in the status quo, that we have release conditions, parole conditions, restraining orders, protection orders, bonds to keep the peace. These are all time limited. One of the concerns we have is that the proposed orders, the non-contact orders, could be open-ended, and we see some difficulties with that. We're told that a problem with some of the existing protections, some of the existing orders, is that many victims are unaware of the existing orders, that they may mistrust the court system, that they're people without internet access or with poor English skills. These existing provisions simply are not accessible to them. And I ask the questions, what's going to change if we simply create another form of protection order, a non-contact order? Is that going to be any more accessible to people who already demonstrably are not able to access the restraining orders, the protection orders, all these other mechanisms that are in place? And I'd echo also Ms Dalziel's comments about the consultation. Yes, it is good to, of course, the consultation should include community law, should include women's refuge or indeed Ministry of Women's Affairs, but it's an extraordinarily limited range of opinion. It was a very limited range of views that seems to have informed this, the drafting of this legislation. So I'd simply ask what's going to change if we don't deal with some of those limitations, some of those barriers to people finding the existing legal protections. What the earthly point of creating yet another layer of theoretical protection, which actually may be no more accessible to those people than what's in place already? This, again, in the RIS, we hear repeatedly this notion of a legislative gap, suggesting there is a gap in the legislation. And I would actually question that. Reference to the bill itself, what would be the effect of a restraining order? And the effects of the restraining order would include an offender against whom an order is made would be prohibited from doing or threatening to do any of the following: watching, loitering near or preventing or hindering access to or from the protected victim's place of residence, business, employment, educational institution or any other place. So loitering, hindering somebody going about their daily business, preventing them from accessing their home, their place of education, their place of work. We have existing legal remedies for that. If I seek to simply hinder somebody from entering their place of work, of course I can be taken to task legally. Equally, an offender would be prohibited from following, stopping or accosting a victim, prohibited from giving offensive material to the victim or leaving offensive material where it may be found by that person. All of this is covered by existing law. I think this notion of legislative gap is something we need to interrogate a bit more. Maybe we need to facilitate access to some of the existing protections for victims of crime. Because as I started out saying, it's absolutely true that a person who has been violently assaulted, raped, subject to some form of violent abuse, understandably will be extremely nervous, arguably, about somebody coming back into close contact into their community. But there is a flip side to this, and we need to look at that wider picture. It's been pointed out that in all likelihood this legislation would be found in breach of Section 18 and Section 26 of the Bill of Rights Act in respect of freedom of movement, in respect of double jeopardy. Are we going to forever punish a person who may have done their time, rehabilitated themselves? Violent offending sometimes is serial, but as often there are one-off events. Somebody gets to a point in their life, they respond violently, commit an unacceptable act, pay the punishment, pay for the crime. Ought we to continue to punish them lifelong punishment potentially for something they've done and which they may wish to put behind them. So where I began, as I say, we do support the purpose of this bill. We need to do more to secure victims' rights, and for that reason we will be supporting this legislation, but we'll be asking some very difficult questions. We'll be seeking to get a much more robust, a much better balanced, a much fairer piece of legislation to look for a mechanism that will serve victims without necessarily imposing damage on others. Thank you, Mr. Speaker.
Thank you. I call the